Next to testify is Joshua Prince, Esquire, Firearms Industry Consulting Group, and also Adam Kraut, Esquire, Firearms Industry Consulting Group. Good morning, gentlemen. You may begin.
Mr. Chairman, honorable members of the committee, I appreciate the opportunity to be here today and discuss these important issues along with my colleague, Attorney Adam Kraut. I'm a licensed member in good standing of the Pennsylvania and Maryland Bar and admitted to numerous courts, including the Pennsylvania Supreme Court, the U.S. Supreme Court, the U.S. Court of Appeals for the Third and Sixth Circuit Courts, and the district courts for the Eastern, Middle, and Western of Pennsylvania. As my curriculum vitae is beyond the scope of my testimony today, I have attached it as Exhibit A to my testimony. Due to the extensive nature of these bills pending, the voluminous constitutional and legal issues with them, and the extremely limited amount of time that we have been provided to address these issues here today, attached to my testimony as Exhibit H is a review of each bill and the constitutional and legal issues that relate thereto. As there are a plethora of unconstitutional provisions pursuant to the United States and Pennsylvania constitutions in the pending bills, I believe it necessary to start by reciting the oath that every member of the General Assembly is required to affirm pursuant to Article 6, Section 3. And I quote, "I do solemnly swear or affirm that I will support, obey, and defend the Constitution of the United States and the Constitution of this Commonwealth, and that I will discharge the duties of my office with fidelity." Article 6, Section 3 then goes on to declare that, quote, "Any person refusing to take the oath or affirmation shall forfeit his office." Yet we see numerous bills being offered with no consideration for the lack of due process, takings without just compensation, and unconstitutional delegations of authority, let alone the right to keep and bear arms, all of which are made inviolate by Article 1, Section 25. Let me emphasize that. All of those rights are made inviolate by Article 1, Section 25 of the Pennsylvania Constitution as ratified by the citizens of this Commonwealth. Worse yet, we see Governor Wolf and Republican members of the General Assembly discriminating against those with closely held religious beliefs, such as the Amish, by seeking to preclude their ability to purchase firearms and ammunition through proposals such as House Bills 1400, 2249, and 2251. Instead of seeking to restrict law-abiding individuals' rights, why isn't the General Assembly proposing and considering true common sense proposals? Why haven't we enacted a law that further codifies the right of school personnel to possess firearms, electronic incapacitation devices, and non-lethal weapons in assuring the protection of our children, like Israel has done since its inception? Professor Eric Dietz of Purdue University, whose Homeland Defense Institute examined school shootings and compiled a report, determined that armed staff and personnel are essential to mitigate the dangers of an active shooter. While Senate Bill 383 was a decent attempt, it suffers from major flaws, which is why I have drafted an amendment to it that would address all the concerns while ensuring the confidentiality of those school personnel who are armed. A copy is attached as Exhibit B. Why hasn't this committee taken action on Senate Bill 5, which has been pending in this committee since April 26th of 2017, when municipalities are flagrantly violating state preemption, which constitutes a misdemeanor of the first degree? How can this committee condone these acts and not take action, especially when 7 individuals were prosecuted under an unlawful ordinance of the city of Erie and as a result incurred thousands of dollars of legal fees with no right to reimbursement? Why haven't we enacted a law that requires notification by the Pennsylvania State Police when a person becomes prohibited from purchasing and possessing firearms and ammunition under state or federal law? If our goal is to ensure that prohibited individuals are not even attempting to obtain firearms and ammunition, I cannot fathom how, regardless of political affiliation, the members of the General Assembly cannot pass such a common sense proposal. For this reason, I have drafted a proposed bill that is attached as Exhibit C. Why haven't we revised Section 6105F to come into compliance with the NICS Improvement Amendments Act in relation to mental health commitments, where Pennsylvania would be entitled to millions of dollars in federal funds for our compliance? A draft proposal is attached as Exhibit D. Why haven't we amended Section 6105.1 to provide for relief from disabilities for misdemeanor offenses, especially in light of the Third Circuit's en banc decision in Binderup versus Attorney General of the United States, where the court held that such prohibitions can violate an individual's Second Amendment rights? A draft proposal is attached as Exhibit E. Why haven't we provided the Pennsylvania State Police with the authority to issue legal determinations under the Uniform Firearms Act, like we have in relation to the Liquor Control Board laws, so that individuals can ensure their compliance with the law? A draft proposal is attached as Exhibit F. If you want to talk about bills that actually protect the public and law-abiding citizen, then these are the bills we should be discussing. More importantly, if you believe individuals who have been adjudicated incompetent, committed to a mental institution, or convicted of a crime punishable by more than 1 year are such a threat to our society to warrant deprivation of a constitutional right in perpetuity, why haven't you proposed a law that would likewise prohibit those same individuals from being able to vote or from becoming reporters or members of the General Assembly? We have youth that believe eating Tide Pods is an acceptable and safe after-school activity, and a small number of people who knowingly break the law to commit crime, yet we're here discussing proposals on how to further restrict law-abiding citizens' constitutional rights rather than address the underlying issues. In closing, an attack on the right to keep and bear arms of law-abiding citizens is an attack on our republic and our founding constitutional agreement. As written by Thomas Jefferson, the laws that forbid the carrying of arms are laws of such a nature. They disarm only those who are neither inclined nor committed to commit crimes. Such laws make things worse for the assaulted and better for the assailants. They serve rather to encourage than to prevent homicide, for an unarmed man may be attacked with greater confidence than an armed man. Thank you, Mr. Chairman, and members of the committee for the opportunity to testify before you today. I will now turn it over to Attorney Kraut.
Good morning, Mr. Chairman, honorable members of the committee. When these hearings were first initially announced, I was quite frankly a little disappointed to see it only included House members. However, I am grateful to be here, and I am glad you extended the opportunity to allow public testimony on the matter here. I, like my colleague, Mr. Prince, I'm a licensed member in good standing of a variety of courts, including the Pennsylvania Supreme Court, as well as numerous federal courts. I won't bore you with those details. A copy of my curriculum is also in Exhibit A. While in law school through October of last year, I was also the general manager of a gun store. So I see this debate from a variety of perspectives, both as a lawyer, having had time behind the counter. During my 3 years behind the counter there, I interacted with people from all walks of life, law enforcement officials, as well as ATF. My experience allows me to see the gun debate from a variety of perspectives. That includes the first-time gun buyer, somebody who's never owned a gun before, coming in for whatever that reason may be, to the law enforcement official who's coming in on official business. It seems that there's a fundamental misunderstanding that many members of the General Assembly and the public have when it comes to firearms and firearms rights. The right to keep and bear arms is not granted by the federal or state constitutions. It's a pre-existing natural right, and that recording of which can be traced back to 13th century England in the Magna Carta. The purpose of the Second Amendment in Article 1, Section 21 is to ensure that the government doesn't infringe upon this pre-existing right. While the Second Amendment is often quoted and debated as to its meaning, and some people like to believe that there is no individual right, even though the United States Supreme Court has said otherwise, Article 1, Section 21 makes it explicitly clear. The right of the citizens to bear arms in defense of themselves and the state shall not be questioned. Looking through the bills that are in front of this committee, it would appear that a number of them violate our state constitution. For example, SB 17 seeks to deny citizens the right to assault weapons and high-capacity magazines, all while violating a number of constitutional provisions, including due process and the takings clauses. And let's be clear here, the term assault weapon is a term of art that was concocted in an attempt to confuse the public and garner support for the banning of a particular class of firearms. You see this Orwellian-style newspeak being employed by various groups with the new buzz phrase, weapons of war. In addition to constitutional concerns, SB 17 would also deny people, especially those who are disabled or of limited size or skill, the ability to adequately defend themselves within their own homes. For some reason, the magic number with legislators is 10. No one needs more than 10 rounds to defend themselves is one of the hallmark battle cries of those seeking to tighten restrictions. Yet, there's plenty of reasons a person may need more than 10 rounds. We continue to see home invasions where there's multiple intruders. There are plenty of incidences that have been reported in the news, such as the woman down in Georgia who had 3 individuals break into her home at 4 a.m. All 3 of those individuals were armed. Perhaps the gentleman in Oklahoma who defended his home against 3 intruders during a home invasion with an AR-15 may make an interesting case study. Let's not forget the heroic 15-year-old who defended his 12-year-old sister in Texas with an AR-15 against 2 intruders. And then, maybe we should ask the woman who shot an intruder 5 times and did not fully incapacitate him. What if she had a gun that was limited to 10 rounds and faced multiple intruders? Would 10 have been enough for her? The practice of law has led me to see the gun debate through an even broader lens. I've had to inform countless clients that they're no longer able to own a firearm because of some nonviolent offense they committed decades ago. I've also had to advise individuals they'd likely be prosecuted for making purported false statements on the forms required to purchase a firearm, all because they were never informed that at any point by pleading guilty to an offense, they would lose their right to keep and bear arms. It seems that a number of attorneys, district attorneys, and even judges don't have any idea as to what offenses lead to the prohibition of somebody. Worse yet, the guilty plea colloquies don't inform people that they're actually going to lose their rights. And perhaps even more egregious, their options for relief are often limited, expensive, and offer no guarantee for the restoration of that right. Being stuck in such a position limits the ability of a person to choose a firearm for self-defense. Now, we've heard a lot of testimony this morning already, and I think there's one thing that we can probably all agree on in this room, regardless of where we sit on the gun issue, and that's the protection of our children. If that's the case, then why are we not doing things like allowing teachers and administrative staff and school resource officers to be armed who wish to do so? I'm not saying we should mandate it, because I understand that people may not be comfortable with that. Why are we not making schools hardened facilities? Is this just merely because it requires an answer we don't like, even though it may be the best answer? And why are we not teaching firearms education in schools anymore? We teach our children about sex and we teach our children about drugs because we as adults understand that kids are going to engage in those activities whether we want them to or not. But we give them the skills and the tools to make informed decisions about that. Why are we not teaching kids how to handle guns safely? So if they find themselves in a situation where one is, they have the skills and knowledge set to act appropriately and leave the situation safely. Before this committee stands a plethora of bills that have been drafted in an attempt to say we did something. These come at a time when emotions are high, and understandably so. However, this committee and the General Assembly should not advance legislation based merely on emotion. It should be passed after careful debate based on logic and reasoning. These are kind of outside of my prepared remarks here, but I did want to touch on a few things that other individuals had mentioned earlier. Mr. Folkrod had mentioned a culture of responsibility, and that seems to be something that is lost as a whole within our society, and I don't think that's anything that you can legislate back into it. I think that's going to have to start in the homes, and I think we as parents, as family members, we need to start instilling that into our communities, our families. Mrs. Goodman had mentioned straw purchasing. I was at a NICS conference at FBI's headquarters last summer, I believe it was. FBI prosecutes, or the U.S. attorneys prosecute approximately 1% of straw purchases across the board. 1%. It's illegal. There's a law against it. They don't get prosecuted. We had an incident where there was a state trooper in the store. There was an individual who turned out to be prohibited, let the trooper know, and the trooper kind of shrugged his shoulders, and out the door he went. Pics being down at gun shows, I heard that was mentioned. I worked at a gun show. I was trying to find the picture because I took a screenshot of it. I must have called pics over the course of 2.5 hours. I'd say at least 25 times before I was able to get to an operator, and then I sat on hold for another hour. So there are some issues with picks. I'll let Mr. Stolfer, I'm sure, is going to expand on that. But having experienced it, I just did want to let you know that there are some issues with picks. And Representative Stevens, your bill, you mentioned that there would be the automatic return of firearms upon the expiration. Part of the issue, to some degree, I have other issues with your bill, but I don't know if you're aware. Part of the issue would be just the NICS being updated as to the person no longer being prohibited. That's not an instant process. So, if you told me today my order was up and I went to go get my stuff back, it's likely I would get denied. So.
Well, along those lines, I'd love to sit with you and come up with a solution to address that. Maybe it's submitting the information, in advance of the expiration of the order so that there's an opportunity for that to be entered or some other solution. But I'm happy to work with you to try to ensure that those folks, upon the expiration of that order, are able to, obtain their firearms again.
Okay. I just wanted to make you aware of that issue. So, and I'll just leave you with this thought. The laws you make are only going to be as good as the willingness of people to obey them. Thank you.
Thank you, gentlemen. Members, please make sure your microphones are turned off when you're not speaking. So, Attorney Prince, you had mentioned in your comments and your written testimony about Senate Bill 5.
Yes.
Are you familiar with House Bill 671?
I am.
Okay, well, then it would have been good for you to mention that we did pass that bill out of this committee twice, last session and this session, and it's sitting in the Senate. In fact, that bill was in the Senate before Senate Bill 5 was even introduced.
And House Bill 671 does not provide all the protections that Senate Bill 5 does, and it is not consistent with what was previously passed and held unconstitutional by the Pennsylvania Supreme Court, not because of the context of the legislation, but the way in which it was added to a copper bill.
Well,
By House Bill 671 are not sufficient. Senate Bill 5 does provide the requisite protections, and I do address it in my Exhibit H.
okay, all right, okay. Didn't realize that, but you only mentioned Senate Bill 5.
Correct, because I believe that's the only true answer currently pending.
Yeah, well, that's a matter of your opinion.
Yes,
Right.
that's what I said.
Okay, thanks. So, Representative Dean for question?
Thank you, Mr. Chairman, and gentlemen, thanks for being here today and participating. A couple of things. Number one, you are part of a consulting firm and you bill yourself as a firearms industry consulting group. Is that correct?
That is correct.
Okay, firearms industry consulting group. I want to dispel a myth that you cited, which is that these bills are brought up hastily and in emotion. I'm sure there's deep emotion around this country and in this room about the loss of life in this country from gun violence. But you need to know that these bills have been brought up session after session after session after session, many of them. So this is something that thoughtful legislators on both sides of the aisle have been trying to do for a long time. So my basic question is, what do you want to do to save some lives?
That's a good question. Well, we can start by looking at what the problems are. It seems like a lot of people like to point to guns as being the issue. We've heard mental health mentioned. Personal responsibility is another one. There's some things that you just can't legislate. You can't legislate the actions of an individual. You can impose penalties on them. We heard about mandatory minimums, things that are deterrent. That's some point of the law. Some of it's punitive, some of it's from deterrent factors. But as far as what you can do...
I would interrupt you and ask you to concretely tell this room that is eagerly awaiting your words. What do you want to do to save lives? You've quoted the Constitution
Sure.
and the constitutional right to bear arms, both in Pennsylvania Constitution and the United States Constitution.
Yes.
Many of us on the other side of this honor the Second Amendment. That's not what this fight is all about. This is actually a fight about saving lives. What do you want to do to protect that other constitutional right, which is the right of life, liberty, and the pursuit of happiness? When our children are killed, when our children are not safe walking into their school, when they are slaughtered as babies, when people going to church are no longer safe, when children in neighborhoods that are racked with poverty are also fearful of the guns they hear at night, what do you want to do to protect that right? I mean it, specifically, concretely. Are you in favor of background checks? Should we close that loophole here in Pennsylvania?
What loophole are you referring to? Are you talking about
The
private
private
party sales?
sale.
Can you point
of-
to a single example where a private party
No,
sale...
wait a second. No, the question
may I?
is from me to you, if you don't mind. You're-
Okay, guys, hold on a second. Like I said earlier today in my introductory remarks, we want to have a civil, professional, respectful dialogue. And I'm hoping that you listen to that again. And I would rather not have applause either. I respect, I know this is a very emotional issue, but let's just calm down a little bit, okay? Go ahead.
Chairman, you're absolutely right, and I apologize. I'll ask you just simply, specifically, concretely, what do you want to do to save lives? Thanks.
Well, ma'am, it sounds like we have a little bit of a societal problem. You point to a couple of different places. You speak about inner cities, you speak about schools, you speak about churches, and we talk about individuals who come that have problems, right? We can start by talking about schools, if you would like. You know, schools currently, most of them, and it's been a while since I've been to a grade school or a high school, so bear with me here. I know when I was in high school, anybody was able to just walk into the school. I know shortly after I left high school, they started to do things like locking the front door at least, and if you were a student, you would get buzzed in, same with people, and you had to check in with somebody. So depending upon the schools, and I don't know all of the details, some have systems in place to at least keep people from just walking right in. Then the question becomes, do you put armed individuals into the schools, be it teachers, and I know you're not in favor of that proposal. Do you put school resource officers there, retired officers? Do you have a dedicated police officer there? I don't think there's a clear-cut answer as to the best way to do it. We're all going to disagree on that. Churches are certainly free to take up their own security measures, and they do. In fact, Mr. Prince spoke at a seminar, which he can tell you about, where a number of churches in the area came together to talk about security plans for their places of worship. So there are things that can be done that don't necessarily require laws to do it. It requires a community response to look at and evaluate what's going on within the community and how can they fix it. What can they do as far as their own private facilities or the public schools, for instance? It doesn't necessarily require a law. And quite frankly, a law is only as good as the people that follow it.
Then I guess we shouldn't have any laws. There shouldn't be laws against murder. There shouldn't be laws against anything. No laws against theft, because some people simply won't follow it. I want to point out an area of agreement that you and I have, and that is education. Education about handling of guns. I utterly agree with you.
Thank you.
And I also agree with you that this might be what we're up to, which is hardening our schools, making our schools more like prisons if we legislatures and if the federal government fails to act to protect our families. Thank you, Mr. Chairman.
I just want to respond one thing, and I am not going to put this out publicly because I do have grave concerns about other potential attacks on our children, but it goes well beyond our schools. It is not just a matter of hardening our schools. There are other related activities that need to be protected, and that is a debate that should happen, but behind closed doors, so that individuals who are likely to carry out those types of atrocious attacks are not informed of those possibilities or ways in which to carry out their terrorism.
Representative Stevens.
Thank you, Mr. Chairman. Thanks again for your testimony. I know you mentioned some other areas of concern. I don't think, and maybe I missed it, I was going through, I didn't necessarily see my bill addressed in your materials. I could have missed it again. I was paging through pretty quickly. But if you had, some thoughts on ways that we might be able to, or concerns that you had with the bill, I'd certainly be interested to hear them because, I'd like to try to address them if we can.
Sure. I believe the extreme risk witness protection order review is on page 8 of Exhibit H.
Right, I think, if I remember correctly, those were two other bills. My bill's House Bill 2227, and those were Senate Bill 18 and House Bill 2109. Mine, I think mine's pretty unique in its approach. We tried to incorporate things from several other states that have adopted them. And also, as I mentioned, had some preliminary conversations with some folks on both sides of this issue and tried to incorporate many of their thoughts. So I'm interested to hear what else we can do.
I believe there's a number of concerns when we look to the constitutional issues, both under the U.S. and Pennsylvania Constitution when it comes to due process. And in fact, that's part of the reason why when we look to federal law, it specifies that a prohibition only results after the individual is provided notice of a hearing, provided a hearing, and an opportunity to be heard, because we acknowledge that due process mandates that notice and opportunity to be heard before stripping someone, especially of a constitutional right. Also, there's a grave concern over the process for those ex parte hearings. I understand that your bill would suggest that public defenders be made available for those who are low income. What about those who are not low income? And quite honestly, in my experience, especially where public defenders are provided under Section 303 of the Mental Health and Procedures Act, I have yet to see a public defender actually defend that individual who is being subject to those proceedings. Generally, it is a stipulation that, yep, this individual can be involuntarily committed for up to 20 more days. So while I don't want to discredit the public defender's office, and it's not a statement on public defenders across the Commonwealth, there is a concern over the amount of cases they have to handle and their ability to adeptly handle those cases, especially when you're going to be placing these additional obligations on them. As an attorney, I can tell you that to represent an individual in this type of situation, you're potentially looking at thousands of dollars. You mentioned the possibility of going out and getting a psychological evaluation. Generally, that's going to cost $2,000 for an MMPI testing to be performed by a psychologist. It's generally going to take 1 to 2 days. That means that individual will be out of work for 1 to 2 days while that testing is performed, all so that that individual can go into a proceeding where there's already been an ex parte order issued against him or her. That is a grave concern when we start to look at the constitutional rights, which again, under the Pennsylvania Constitution, are acknowledged to be inviolate.
Has the court, and this is your area of expertise, has the court opined on the constitutionality of the current ex parte proceeding with regard to PFAs and, frankly, 302s?
They have not, with regard to my knowledge, with regards to ex parte PFAs. They have just recently, the Western District of Pennsylvania, in a case I litigated, Alton Franklin versus Sessions et al., held that because of the lack of due process provided under Section 302 of the Mental Health and Procedures Act, it is not sufficient to trigger a federal prohibition because of the absence of that due process.
But that's only in the Western District. In the Middle District and the Eastern District, the standard of the 302 being a lifetime prohibitor still is in place, even absent those due process protections.
It's my understanding that that's the position of the U.S. government. It's hard to fathom how that is a correct interpretation based on the court's determination that it doesn't meet the requisite due process analyses.
Yeah, I don't disagree with you. I'm not quarreling with that contention that the 302 procedure is devoid of due process that probably should be incorporated when you're talking about a lifetime deprivation of a constitutional right. I can understand that. And frankly, we had that in mind when we were drafting my bill. So I guess if the ex parte provisions regarding the PFA Act have been upheld as constitutional,
they haven't been upheld as constitutional. They haven't been challenged. Again, you're talking about tens of thousands of dollars that an individual or entity would have to put forth to actually challenge these types of provisions.
So they haven't, I mean, look, if they haven't been struck down, and they've been in place for many, many years, certainly, you know, thousands and thousands of individuals have been subject to them. I guess I'm trying to understand upon what legal authority, you know, you make that statement that
Constitution.
no, I get it. And I understand you're entitled to your opinion about what the Constitution says, but as someone who's been elected a judge in the Commonwealth of Pennsylvania, do they happen to agree with your opinion as it relates to that ex parte proceeding?
There's never been a challenge because it's a limited period of time. There's only 10 days for an actual hearing to be held on the underlying PFA. So there is no real opportunity for someone to mount a full-blown challenge because by the point in time the challenge would be determined, it would in essence be moot.
Well, I mean, you could seek to get an injunction to prevent the imposition of that disability immediately, right? I mean, you have the ability to seek that relief. Do you envision any scenario where an ex parte proceeding could, for the slightest period of time, limit the right to keep and bear arms?
The U.S. Supreme Court has acknowledged that in the absence of a hearing being provided pre-deprivation, there are occasions where a post-deprivation hearing is sufficient. However, it must be held in a very close proximity to the ex parte order, and you must obviously provide the other individual, the person who's being aggrieved by it, the opportunity to be heard and to provide a defense. So I acknowledge the U.S. Supreme Court has even stated that there are occasions, but they have limited those occasions, whereby someone can be temporarily denied a even constitutional right, provided that there are mechanisms in place for a timely hearing.
Okay, so if you don't mind, I mean, if you want to get me that site maybe, that would be terrific, and we can try to make sure that we are staying within the confines of that jurisprudence as it relates to the constitutionality, and then that may be one way to address those constitutional concerns that you raised. It seems like that might be the right direction to start looking at what parameters the court has already laid out, right?
The concern is obviously vindictive use of these processes, and I handled a case out in Cambria County where an individual had over 300 firearms taken in relation to an ex parte PFA. When the hearing was held on the final PFA, the judge was so incensed by the lack of any basis for not only a final PFA, but even for the issuance of the ex parte PFA, that he vacated both and ordered the firearms to be returned. However, then the court directed that the respondent, who was found not to have done anything wrong, had to pay the fees of the sheriff's department for going out and taking his 306 guns, and there were thousands of dollars being assessed against him for having done nothing wrong. Thankfully, we had a judge where, when we addressed the constitutional issues before him, said, no, this is wrong, and directed the sheriff to return all the firearms at no cost to the respondent.
Well, one of the provisions in my bill does require, or does provide for penalties for those who would provide false information. And I know, certainly I appreciate your support for mandatory minimum sentences. That's been my bill for the last several sessions. I've also did the bill to increase the penalties for those who are illegally possessing firearms, things along those lines. So I share your feelings in that regard, and I think that would be applicable here. If we provide for some strong penalties for those that would abuse this approach, I think we can deter that type of conduct and ensure that people are not being wrongfully ensnared with, with these provisions. So again, I'm happy to work with you to make sure that there are robust penalties for those that might abuse this approach for some ulterior motive. Happy to work with you in that regard.
I look forward to it.
Thank you.
So within this time segment, we have time for one more question. Representative Saccone.
Thank you. Thank you. Thank you for your testimony. The question was posed, what can we do to save lives? And one of the comments was that our children are being slaughtered as babies, and we tend to point to the instrument as the problem here, in this case guns, but if you want to use that logic, then I say we can ban those abortion scalpels and we'll save 30,000 lives a year. So what we can do, though, do you agree, is have threat assessments for all of our schools, because every school is different. There's no cookie cutter solution to our schools being hardened one way or another. Some schools have certain techniques they've already applied. Some might not need them. We need to look at each school independently and see what the threat is and what techniques we need to make that school safer.
Absolutely. I completely agree that we need those threat assessments. I believe there are organizations, I believe one is in attendance today, Rockwell Tactical, that has experience doing it not just for schools but also for churches and other court facilities. They've done some phenomenal work with, I believe, the Chester County Courthouse. So there are those organizations that stand ready here in the Commonwealth already to provide those threat assessments for schools. And I know there was a comment made about the recent shooting and the fact that the school was hardened there. I'm not so sure how hardened it was when we had an individual able to walk in with those firearms without being checked. Why aren't we going to clear backpacks? Why aren't we having metal detectors in the schools? Why aren't we taking those precautions to prevent these types of attacks, as well as having armed either teachers or resource officers that are available to respond to situations? As I said in my testimony, Israel has been doing it since its inception and has been doing it very well. We could take some great advice from Israel and how they have ensured that there aren't these types of atrocious attacks in Israel, and we know that in Israel they're under constant attack.
The NRA also does have a program that's provided free to schools who want to utilize it for exactly that kind of assessment as well. So that is another option. Obviously, it's up to the school to seek it out, but options do exist.
Thank you, gentlemen, for your time and your testimony. I'd like to recognize Representative Schemmel, who's joined us. So next to testify is Mary Beth Stanton Christensen, Moms Demand Action, and also Sarah Higginbotham, Every Town for Gun Safety. Welcome. You may begin when you're ready.